A very warm regards to you all. My name is Sanjeev Roy and I welcome you all on behalf of IASbaba. So today we are here to analyze the questions asked by UPSC in mains paper of GS2. So the GS paper 2 questions, GS paper 2, the subjects that's there is polity and constitution, right? Polity and constitution, and after that we see social justice followed by governance. I'm talking in the series in which the syllabus is given, and then comes governance, and after that, after governance comes IR. So this year, more or less, UPSC has followed its trend. So whatever trend it used to follow, it has taken that trend only. Like no extraordinary things, like no reduction in polity and constitution questions, or social justice or governance or IR. Maybe one or two upper niche fluctuations and all that you can find, but rest of the things are in very much sync, right? So before we proceed towards the questions, I need to tell you what you need to expect or what you can expect from this session. From this session, very strictly saying, you should not expect anything, as in terms of model answers, because I am not here to give you model answers, right? We will solve the questions, we'll see the questions and we'll try to sort it out. The model, the answers are there, but don't expect that from this session. What you should expect is the syllabus and the mapping of questions, as per syllabus. That's one thing, mapping of questions you can expect. And the second thing that you can expect from this session is the significance of UPSC previous year's questions in your preparation. Significance of UPSC PYQ in your preparation, right? Like, why I am saying this? If a new candidate would have prepared for UPSC CSE examination and you are a veteran, you are having knowledge of everything in the syllabus, but you have somehow or for some reasons you may be a bit callous in your approach to see the previous questions asked by UPSC. But the new candidate who is appearing for the first time in mains examination, due to paucity of time or maybe because of any other reason, that fellow have prepared his syllabus or his prepared for this examination through the previous year's questions. That new candidate would have scored better marks as compared to the veteran. Because throughout the session, I'll show you that no question except one or two, and that too was on expected trends only. No question was there in this examination which was not there in previous year's questions. You are getting my point? You see, and we shall see, I have taken down all the questions asked from the topic, from the question on the basis of the topics, right? So we'll see that. See, I always tell my students to focus on syllabus. But syllabus, you know, it's a very vast and dynamic, extremely vast. Everything under the sun is the syllabus of the UPSC, and we all know about that, right? The next thing that we need to say is what matters or what makes the difference is that previous year's questions, right? Like, this question sets actually the theme of the UPSC preparation. right? So we need to make some difference. This makes not some difference, actually it makes a lot of difference in your preparation. As this session proceeds, we shall see all those things, right? So like I have divided the syllabus over here, or the division of syllabus is there. We'll go in this way only. We'll start with polity and constitution, followed by social justice, questions asked from social justice, then governance, and after that we'll start with the IR section, right? And we'll see how the questions have been asked. The other important thing that was observed in this question paper is two things. One, that current affairs makes a lot of difference. Current affairs, a lot of difference. So you need to update yourselves with the current affairs, but that current affairs, in pursuit of current affairs, or trying to achieve excellence in current affairs, you should not at all ignore the static portion. So there is always significance of static portion. We'll see, like Attorney General is there, like pardoning power of the President is there. So you cannot ignore this static portion at any cost, right? So that also becomes very much important, and previous questions I have already talked about. So we shall see the integration of these two also. The third thing that was observed in this paper is integration of two topics. Integration of two topics. They are trying to make the question very interesting. Integration of two topics. They are trying to make the question very interesting by integrating two topics of the syllabus, like executive. So what happens is executive, president's power of to pardon, that comes under the executive power, right? But they have integrated that with comparison of constitution with other constitutions of the world. So what happens is, now that question becomes interesting. So pardoning power of the President, and they have asked to compare it with the pardoning power of the President of the United States of America. So this is very much important for you to understand, right? So integration of two topics, and that they are doing like since time immemorable, right? So we cannot remember as well since when they have started this trend, and they have followed that in this examination as well. Apart from that, the rest of the things are, you know, in line with the UPSC only, right? And I always say that the papers created by UPSC is not actually the, it's not questions. It's not simply questions. It's not just a piece of paper or examination. I consider the questions as the craft. And as the session proceeds, I hope that you guys will agree with what I am saying, right, by the time we end the session. So now let me start with the session, right? So this is the first question, polity and constitution. As I have said, I have started with polity and constitution, right? So polity and constitution. So now we are starting with the polity section, polity and constitution. So now, as you can see the question paper over here in front of you, the first of all, the syllabus, salient features of representation of People's Act. Salient features of representation of People's Act. Now, this topic you are seeing, right? You can find this topic directly over here in the examination. All this is Representation of People's Act 1951, right? So this you need to take care of very nicely, that you guys have to prepare for this, right? So whatever is there in the syllabus, first of all, you need to prepare this. So had you prepared this topic, you would have done well in the examination number 1. Now the question is, let's see the question. The question is that discuss the corrupt practices for the purposes of discuss the corrupt practices for the purposes of Representation of People Act 1951, analyze whether the increase in the assets of legislators, right, of legislators and their associates, right, legislators or their associates, disproportionate to their known sources of income would constitute undue influence and consequently a corrupt practice. So what they are saying is that discuss the corrupt practices for the purposes. You need to remember the definition of it. What is corrupt practices under this article, under this act? Before we proceed with the model answer, you just see here the previous questions, right? The previous question says there is need for simplification of procedure of disqualifications of person found guilty of corrupt practices under Representation of People's Act. And this question was asked in 2020 only. This question was asked in 2020 only. 150 words, 10 marks. This time also they have asked 150 words, 10 marks only. So had anyone prepared this syllabus, and in this syllabus, this theme, they would have been able to answer this question really appropriately, really nicely, and this 10 marks would have been the easiest of the score, easiest of the marks. Now, how can we sort this out? So, you see, throughout the session, insofar as answer writing is concerned, no matter what do I say, all the questions I'll be answering in actually 6 dimensions. 6 dimensions. What dimensions that will be? This will be why, what, and then pros. Maybe some different terminologies will be there, and cons, and after that steps taken in that regard, and then there will be recommendations, and accordingly we'll try to answer the question whatever we have at our hand. So now we'll see that in the question we saw on the corrupt practices, you see how we are breaking it down. First of all, the thing is that we need to know whether there is anything in news. We need to know that whether there is anything in news with regard to the corrupt practices, right? And after that, we'll see what about RPA 1951. So RPA, Representations of People Act 1951, we need to write provisions and a definition of corrupt practices. So why done and then what done? Now, increase in the assets of legislators disproportionate to their known source of would constitute undue influence and consequently corrupt practices. So you need to understand that how undue influence, when they are talking about, they are actually talking about the undue influence in the elections, right? And similarly, increase in the assets of their associates disproportionate to their known sources of income would constitute undue influence and consequently a corrupt practice. So you see, in these two things, they had asked one question only. We have broke that down into two things. Now here, what we need to understand it is, first of all, what was there in news that we need to see, and after that, we'll see what all can be done in that, right? So here we are seeing that yes, ADR 2023 was there in news, and they had said about rising legislators' assets, and Supreme Court as well in Lok Prahari case they had flagged disproportionate asset growth. So this was already there in news, right? Now what becomes important over here is that free and fair elections. Free and fair elections is the basic structure doctrine, and that the Supreme Court had observed in Indira Nehru Gandhi case way back in 1975, right? Having said all this, we have set the context, right? And of course, whenever the Representation of People's Act come in the examination, it talks about elections only, because RPA is related to that only, the MPs, MLAs and all of them, right? So section 123 of RPA Act defines the provides framework for elections corrupt practices defined under section 123. So we have seen that this has been defined over here. Having said that, now what happens would will increase in the legislators asset amount to, you know, the undue influence or covered under corrupt practices? So that we need to see in this. So what we'll see is that it is actually not a corrupt practices per se. Like if suppose a legislator has a disproportionate asset, that per se doesn't amount to corrupt practices. It amounts to corrupt practices only when that asset is involved in elections, in influencing the voters. So in that case only that undue influence wala thing comes into picture. And the next, the associate, their associates as well, if we see their source of income and consequently that constitute undue influence or consequently a corrupt practices or not, so that also the same thing. If you have disproportionate access, disproportionate assets, that doesn't tantamount to, you know, the corrupt practices at all. That is covered. That is not even covered under RPA Act 1951. That is covered under the Income Tax Act, right? So if you have asset disproportionate to your income, so that will be covered under what? The Income Tax Act, not under RPA. But yes, when you are trying to influence the voter by distributing cash, by distributing something else just before elections, like we all know, chicken and liquor is distributed into the constituencies just before the night of elections, and people also get influenced by that. The next morning they go and they vote for the same person who has given them that liquor and chicken, right? So we know that. So if someone is found doing that, that will be covered under undue influence, and that will be covered under this corrupt practices. Consequently that will be a corrupt practices, right? If associates enrichment is seen, that will be linked to quid pro quo, like this for that, right? Something for something, you can say. So that is what is covered under this, and if that is channeled for campaigning, distribution of money, liquor, freebies, it constitutes basically bribery or undue influence. So I hope that is clear to you all, right? What are the steps that has been taken so far? So we see that Lily Thomas case, in that case Supreme Court has said that immediate disqualification of convicts must happen. In this PU sale case, they have said for mandatory disclosure of assets and liabilities. Mandatory disclosure of assets and liabilities. So that they had already said about or talked about, right? So now what is the next thing is that Election Commission, they have given an affidavit which needs to be disclosed, you know, by the candidates just before contesting it, and after becoming as well, they have to disclose it, right? And what are the legislation in this regard? So Prevention of Money Laundering Act, Benami Property Act, to curb black money entering elections. These are the things. What are the recommendations? So the recommendations are Dinesh Goswami committee, they had said a stringent asset disclosure thing. Vohra committee, they had flagged politician, criminal and business nexus. Law commission, Advocate enhanced election commission powers to scrutinize disproportionate assets case. And in conclusion, you have to either close the question. In conclusion, you don't have to bother much. I have found or I have seen students struggling with writing conclusion or something like that. It's you don't have to make it a rocket science. You can simply close the question by answering this. Thus, by aforementioned provisions, we can see that it is covered, what is covered under the corrupt practices under Representation of Peoples Act 1951. So this is a very important thing that we just saw. So what did I do in this is, what did I do? You need to remember this as well. I just showed you two things: why, what, pros, cons, steps taken, and recommendation. Now, the next step in this that comes is, like what, why, first to why. So, is this in news, or why this question? Is this in news? So that is one thing. Is there any judgment, or anything like that, any report or something, whatever? In what you have to define the issue, define what has been asked. Like in this case, we had to define corrupt practices. In this case, we had to define what is the provision that in which this corrupt practices has been defined. That is 123 of RPA, right? 123 of RPA. Now, this pros and cons was covered in the question only, because the question was asking whether it defines the undue influence or not. So we saw that it covers undue influence in what circumstances, and then there is steps taken. So steps taken, we saw. In the steps taken, we bring in everything. The Supreme Court judgment, the legislation, right? Some policy is there. If there is any policy that is being followed, acts, schemes, yojanas, whatever is there, yojanas, or some maybe committee has recommended and that is being followed. In recommendation part as well, we can see what Supreme Court had to say, what committees had to say, what reports and indices has to say. So all those things we can write in over here, and we shall see through the rest of the questions as well. So the next question comes is separation of powers. The syllabus is separation of powers between various organs and dispute redressal mechanisms and institutions. Dispute redressal mechanisms and institutions. Now this is the syllabus. The question is comment on the need of administrative tribunals as compared to the court system. Need of administrative tribunals as compared to the court system, right? So assess the impact, the next part, assess the impact of recent tribunal reforms through rationalization of tribunals made in 2021. So see, once again, the recent trend that is being followed, they are interested in, right? And the first thing is the need of administrative tribunals as compared to the court system. We all know that it's in debate. That court system, there are a hell of a lot of pendency of cases, and there are many other things that's there. There is flaw with them, right? Now, a question is there, fine. Now let us see if there is something in the previous questions or not. How far do you agree with the view that tribunals curtail jurisdiction of ordinary courts? What is that? How far do you agree with the view that tribunals curtail the jurisdiction of the ordinary courts? Do you agree? And if you agree, how far? To what extent, basically? In view of above, discuss the constitutional validity and competency of tribunals in India. This was asked in 2018 and it was covered in 15 marker. Now, had you prepared this question asked in 2018, don't you think this year you would have performed really well, or the students, those who would have prepared it would have done really well in this question? So once again, this is the syllabus, but this question sets the theme, they have narrowed it down, and almost they have repeated the question in 2025. So 2018. Now let's see another question. Explain and distinguish between lok adalats and arbitration tribunals. Explain and distinguish between lok adalats and administrative tribunals, whether they entertain civil as well as criminal cases. Now, this question was asked in prelims, whether they entertain civil or as well as criminal tribunals के बारे में. So UPSC prelims and mains are all connected over here, right? So this, you see, explain and distinguish between lok adalats and tribunals. I got it. This is not direct, but at least arbitration tribunals are there, right? And here the administrative tribunals are there. So you can relate that they are these questions actually setting theme for the syllabus, that is dispute redressal mechanisms and institutions, right? So now what is the question? The question, whatever the question says, that is fine only. Now you have to see what all we can do. Here you see about, we can in intro we can write about administrative tribunals, or what are the recent tribunal reforms through rationalizations of tribunals made in 2021, and if there is something that in the news about this examination, about these tribunals and courts, so of course that will be there. You need to look for it. If you will read current affairs, you will be getting something like that. Comparison. The next thing what we can do, comparison between administrative tribunals and the court system, with emphasis on positive of administrative system with the negatives of the court system. See, you need to understand the tone and the tenor of the questions asked by UPSC. That is very much important. If the question is setting the tone that you tell me that administrative tribunals are better, so you have to talk in that terms only. But it's not like you have to talk only in the favor of administrative tribunals. Rather, you have to also talk in the favor of court systems. But yeah, the leaning should be like, if you are writing 10 points, then you need to write 6 points that will be in favor of administrative tribunals, and 4 points will be in favor of the court system, right? So that becomes really important, right? The next thing is positive impact. You have written the how far let's see the question once again. The question says is, assess the impact of recent tribunal reforms through rationalization of tribunals in 2021. So you have to talk about what the positive reforms, positive impact of the tribunals. You have to talk about the positive impact of the tribunals, recent tribunal reforms through rationalizations made in 2021. And then you also have to talk about negative, because assess the impact, they said. That is neutral, but assess is there. So you have to say both the things, that positive as well as negative, but the importance will be onto the positive side. So once again, if 6 points, 4 points for this, 2 points for this, like that, right? And what are the steps taken? Judgment, committee, laws, policies, schemes, or whatever, recommendations, same committees, recommendations, the judiciary, if they have said anything, any body or constitutional body, or the statutory body, if they have said anything of that sort. So you need to understand these things, and based on that you need to write the model answer. So once again, of course, when you will decide, when you will define the administrative tribunals, that was actually incorporated into our constitution by inserting article 323A and 323B by 42nd Constitutional Amendment Act, and these are actually quasi-judicial bodies. And I'm telling this to you, we shall see in this as well, that there is a lot of demand of the tribunals. Why? Because there is this difference between tribunals and the court system. What is the difference between administrative tribunals and the court system is that there is a specialization into the tribunals. In the court system, the judges are giving their judgment on different issues, but they are not the experts. They are not the experts of the topic. Rather, they are simply a generalist and yet delivering justice on very technical subjects. They do not know the subject matter. Right, and in this examination, as we proceed, we'll see this time judiciary has also been trolled by UPSC. They have been, trapped into their own trap. The judiciary has been trapped into their own trap, and we'll see how. And after seeing the question, I actually laughed about it as well, right? So let me see. Let us proceed with this. So, in this, why did the need arise? Of course, huge pendency with the court system, specialization that is there available in the this tribunal system, accessibilities, they are quicker, cost effective, and they are easily accessible by all. And ease of procedure as well is there, like Civil Procedure Code and Evidence Act are not required in that tribunal system, right? What was the reform? What was the reform in 2021 that they have talked about? So that also is very much important for us to realize. This is rationalization. They reduced the number of tribunals from 29 to 19. That's very important. And then appointments. They introduced a uniform search cum selection committee headed by Supreme Court judge or the nominee. The tenure and the service commission, this minimum age of 50 years, 4-year tenure. Later, increased after SC intervention, right? And then the aim is to increase efficiency, uniformity, and the reduced overlap, right? So this rationalization was there. Now let's see the comparison. As I had mentioned in the layout only, that we need to see the comparison as well. Comparison between administrative tribunals and the court system, right? Administrative tribunals and the court system. So what is the purpose? Specialized bodies, right? For service, tax, telecom, environment, etc. And then generalized. This administrative tribunals is one for administrative tribunal and other for the 323B is for other purposes, right? And then comes general jurisdiction, civil, criminal, constitutional matters, whatever court system have. This on everything. Procedure. This is flexible, not bound by CPC or Evidence Act. This is strict adherence to CPC and Evidence Act, right? Expertise, members, like all of this you can see. Take a screenshot and keep it with you, right? So the next is, what is the impact? The positive impact and the negative impact and all that we can see. So they reduced it, right? The appointment, uniform selection and search committee, the standardized across tribunals, that is uniformity, efficiency and judicial oversight. Here the negative will be loss of specialized forums and executive dominance in appointments raised concerns. There is this appointment always causes concerns in judiciary as well as in the administrative tribunals. What are the steps taken? So the Central Administrative Tribunal System, Indira Sawhney case, they said, no, this is fine. They upheld it. Then judicial review by Supreme Court and High Court cannot be excluded. So whatever judgment the tribunals gives, their judgment can be reviewed, and judicial review is possible of those judgments. Law Commission Report 272nd and 277th stress autonomy, longer tenure and adequate funding. And these are the recommendations that were given. Law Commission, second ARC, SC directions, and ECOSOC model, that is international, right? And after that, the conclusion. Conclusion, you have to give it, right? Now comes the next question. And the next question is very important. Let's see the question. Compare and contrast the President's power to pardon in India and in the US, in India and in the US? Are there any limits to it in both the countries? And what are the preemptive pardons? What are the preemptive pardons? So first of all, when we go to the check the syllabus where it came from, there is a syllabus called a Structure, Organization and Functioning of the Executive and Judiciary. Later that those things are there, but I cut it from till here only. So executive, a president is executive, and this power to pardon is actually an executive power, right? And then there is comparison of Indian constitutional scheme to that of the other countries, right? Comparison of Indian constitutional scheme. So these two topics combined together makes one thing, right? And after that, when we saw this, if you would have prepared to these two topics, you would have done really well in the examination center. But having said that, what are the themes under these topics on which we needed to prepare? So for that, we need to see the previous questions. So now let's see previous. Under what circumstances financial emergency be proclaimed by the president? Once again, the emergency powers of the president are actually the executive power. So executive only, right? And what consequences follow when such declaration remains in force? So sir, this question doesn't directly reflect this kind of the kind of question that has been asked. Okay, fine, agree. Second question, let's see. Instances of precedent's delay in commuting death sentences. In commuting death sentences has come under public debate as denial of justice. That's true. Should there be a time limit specified for the president to accept or reject such petitions? So, okay, they have said so, and I agree to an extent that a delay of justice must not happen. If you have to hang the person, hang the person. If you have to pardon the person, pardon the person, right? That hanging in the middle shouldn't be the case. So this pardon power is here, one, directly. Now what they did is, this time they changed. They compared it with the United States. Now that comparison is not from somewhere in the air. Now let us see previous discussions to understand a bit more about it. So what is the previous question in this regard? Say comparison of the constitution. Discuss India as secular state, secularism, right? And compare the with the secular principles of the US Constitution. India as secular state and US as secular state. So secular feature of India, secular feature of India and US was asked to be compared. India and Indo-US was asked to be compared. Okay, sir, एक ही question था. Let's see. Analyze the distinguishing features of the notion. Analyze the distinguishing features of the notion of right to equality in Constitution of the USA and India. So once again, you need to, do what? Right to equality, right to equality. You need to compare it of what? India and USA. Indo-US you need to compare. So once again, the first question secular, second question right to equality, and what is the third? India and USA are two large democracies, correct? Examine the basic tenets on which the two political systems are based. So once again they asked to compare, and that is democracy and the basic tenets of democracy of who? USA and India. So these are the three questions asked in 2018, 2021 and then 2024, and this question was in 2014 and the upper 2018. So almost all the years they have given you the clue. They have given you the theme to prepare that syllabus from. So now you don't have to prepare the syllabus in its entirety, and that too, blindly. You have now got the themes. Now the questions you need to pick up from this thing. to compare or to prepare is 2013 to 2025. Now 25 is also available. So if you would have prepared the questions from or the themes from 2013 to 2024, you would have excelled in this examination really well. So till now we have done 3 questions, I believe, and all the 3 questions I have shown you by example, with proof that they have asked almost same questions from the previous question. That is basically the repeat only, right? Now you will be more interested into the the model answer and all. I don't believe in all those things. You can prepare it well, or you can see here as well. Intro. About the president's pardoning power, you please mention. Compare and contrast president's power of pardon in India and the United States of America. Are there any limits in it in both the countries? Of course, there will be limit. And what are the preemptive pardons? This is not with India. This is with the USA. This is with the USA. Preemptive pardon is something like you can pardon a person even before being convicted. So if suppose against some person there is some case or something like that, and president wants to pardon that person, so that person can be pardoned. That is with the United States of America. Presidents of the United States of America has that power, not the Indian president, right? So that is also one very important point that we just saw, right? Now, what is the model answer? You can see pardoning power of the president, Article 72, that covers, and that is what is mentioned over here. In the United States of America, Article 2 and Section 2, it is power to grant reprieves and pardons, right? This was in news actually. Now you will say, sir, so many things are there. All the things cannot be compared to the Indian and USA Constitution. That's true. But this was in news this time. I think President Trump had pardoned someone. So if you will follow the news rigorously and seriously, then you'll get everything actually. And following the news means reading that seriously, taking notes out of that. And the notes should not be, all the newspaper is there in your notes. No, you need to take selective part, very selective part of it, right? So all those things you need to take care of, right? And then after that, we can see the comparison of the, debate on remission of convicts in high profile cases, example for Bilkis Bano case, and use of pardoning powers by US presidents. Donald Trump's preemptive pardons stirred global discussion. Concerns over judicial review and executive accountability have been highlighted by Supreme Court of India, right? And now there is a table you can see, and there is the comparison. In India, it is Article 72, union law offences, military courts, and death penalty can be pardoned by the president, and only in these 3 cases president can pardon. Presidents act on the aid of and advice of Council of Ministers. That also is very much true. Here in the United States of America, Article 2, Section 2, and federal offenses except impeachment, right? And presidents act independently, like not on the aid and advice of Council of Ministers. And in the United States of America, there is no judicial review whatsoever, right? That is absolute discretion of the president. But in India, Supreme Court and High Court can review on malafides, or arbitrariness. That was as per the Ipuru Sudhakar case judgment in 2006. This is collective executive responsibility, and this is unilateral presidential prerogative. In India, they are bound by the aid and advice of the Council of Ministers, that is Article 74, and subject to judicial review, right? USA, they cannot pardon impeachment. In the United States of America, that is limited to the federal offenses, and courts cannot question the decision, and the courts cannot question the decisions, right? This one. All right. So these are the things that is there. Now we are moving to the next question. The next question is, discuss the nature of Jammu and Kashmir Legislative Assembly after the Jammu and Kashmir Reorganization Act 2019. briefly describe the powers and functions of the Assembly of the Union Territory of Jammu and Kashmir. So now you need to understand this. This was one of the questions that had not been asked previously. But if I had to take anything from, NCT of Delhi had been asked, right? The NCT of Delhi, that was, I think, that had been asked many a times actually. Right, so I think once or twice that question have been asked. So from there you can see that this time, for the first time and after so many days, the election had happened in the Jammu and Kashmir. So that was also there in news. Right, that was also very much in news. So if you have to take inspiration, you can take inspiration from NCT of Delhi Act, and from there they have asked. And the syllabus part will be functions and responsibilities of the union and of the states, issues and challenges pertaining to federal structure. So I think this was a very popular question, one of the expected questions, and you could have answered it very easily. So many conflicts are going on between, the administration or the administrator of the Jammu and Kashmir, Sri Manoj Sinha Sahab, and the Chief Minister of the state, that is Omar Abdullah. Right, so those two people are almost in conflict. Recently we saw on Martyrs Day as well, the Chief Minister was trying to jump the boundary of that premises. So that was also seen there. So this is what is there, and based on that we need to answer the question. I think this question would have been answered by all the serious aspirants. Serious aspirants would have answered these questions really well. So what you can write in this: about Jammu and Kashmir Reorganization Act, 1. About nature of Jammu and Kashmir Legislative Assembly, number 2. And the next thing is, what are the powers and functions of the Assembly of the UT of Jammu and Kashmir? And also we can compare this power. We can compare this powers and functions of Assembly of UT of Jammu and Kashmir with that of Delhi and with the rest of the other states. We have done that as well in this part, right? So what we can see in this is, in the model answer, Jammu and Kashmir. Special, now we can see when this special constitutional status was removed under Article 370 was revoked on 5th August 2019, and consequently this Act, Jammu and Kashmir Reorganization Act, bifurcated the Jammu and Kashmir in union territories, 2 union territories, one of Jammu and Kashmir and the other with a legislature, and the other is Ladakh without a legislature, right? And this act redefined political and administrative setup of the region. About Jammu and Kashmir Reorganization Act, what all they did, we have to write in that. And then nature of Jammu and Kashmir Legislative Assembly, like there is limited autonomy, and they can make law on state and concurrent list, except that is public order, land, and there is one more thing, police. So these 3 they cannot make law on. That remains only under the center, and rest of the subjects have been delegated to the legislature, right? So this is kind of comparison you can write so that it will look a bit beautiful as well, and people can understand. So J&K of UT, Delhi UT, Puducherry UT, and other UTs. So legislature, yes, yes, and yes. So 3 UTs are there with the legislature. What are the subjects that have been excluded here? Police, public order and land, police, public order and land, law and order and police. Land is not excluded in Puducherry, right? And all powers are with Parliament. About the rest of the UTs, we can say. Status, larger assembly, 114 seats. The 7 seats have been increased, right? Here 70 seats and here 30 seats. No elected assembly whatsoever. And then governor or lieutenant governor role, and what is the unique features. Those things you could have mentioned, and that would have fetched you more and more marks. Now the next question. This is, I think, very much, from the syllabus. It is part of the executive only. There are actually 5 union executive, that is President, Prime Minister, Council of Minister, and Vice President, and Attorney General. These are the 5 union executive as per the Constitution. And Attorney General is in the 76th article, right? 76th article of the Constitution. So before we move further, we need to see the question. The Attorney General of India plays a crucial role in guiding the legal framework of the government and ensuring sound governance through legal counsel, right? Discuss his responsibilities, rights, and limitations in this regard. So this is what we need to see. Discuss his responsibilities, his rights, and his limitations, right? You need to break the question. You need to learn the art to break the questions. And if you are able to break the questions, you will be able to answer the questions as well. Now, before proceeding further, what is the topic? What is the topic in the syllabus? The topic is structure, organization, and functioning of the executive. Now, is there any question asked in the previous question? And that question is, the Attorney General is the Chief Legal Advisor and Lawyer of the Government of India. Discuss 2019 only. In 15 marks. This time they have asked in 10 marks. So you need to, if you would have prepared this topic, you would have been able to answer. More refined in your approach you would have been if you would have prepared the theme on the basis of the previous year's questions. So once again, this would have been an easy cake for you all. About Attorney General of India, what we need to write in intro about Attorney General and the responsibilities of Attorney General of India, rights of Attorney General of India, and limitations. Responsibilities, rights, and limitations. So all these things you needed to write in, right? And that is what is written in the model answer as well. Attorney General of India under Article 76 of the Constitution, and all those things are written. Recently, we have seen this Attorney General of India. That fellow is always in news actually. So because he defends the case of the Government of India, like CAA, like electoral bonds and all, right? And what are the responsibilities, what are the rights, and what are the limitations of the Attorney General of India, we all need know, right? So accordingly, you need to write the questions as well. Now, the question is constitutional morality. This is the question I was talking about. The judiciary has been trapped in this question. Judiciary, talks, and as a right winger, I am saying this. So, judiciary actually talks a lot, big thing, when they have to, encroach something of the legislature or something of the, executive. They are the ones who encroach into the legislatures or the executive's territory or jurisdiction, you can say. But they don't want the legislature or either the executive to encroach into their jurisdiction. So this time, what question have been asked by UPSC? It's very interesting. The judgment they have quoted of the Supreme Court. You see the judgment. Constitutional morality is the fulcrum which acts as an essential check upon the high functionaries and the citizens alike, right? Constitutional morality is fulcrum which acts as essential check upon the high functionaries and citizens alike. That's true. It's true. Now, the question you say, in the view of the above observations, Supreme Court explain the concept of constitutional morality A and its application to ensure balance between judicial independence and judicial accountability. Both is related to what? The judiciary only, and judiciary under the garb of judicial independence, or they do not bother about the judicial accountability. Right? So this is what this time UPSC wanted us to answer. So this question will be covered under this significant provision, constitutional morality. Got it? Okay. Now we need to see what? We need to see that whether this was asked in the previous year's questions or not. So when we see the previous question, when you'll delve into it, you'll find a question: constitutional morality is rooted in the Constitution. Constitutional morality is rooted in the Constitution itself and is founded on its essential facets. Got it? Explain the doctrine of constitutional morality with the help of relevant judicial decisions. So this was the question that was already asked. This is not a new question. If you would have prepared this constitutional morality wala theme from 2021, I think you would have been able to answer this question really easily, because in judicial independence and judicial accountability, you would have hell a lot of content. The only thing is the constitutional morality. Now, what is constitutional morality? If we talk about the basics of the constitutional morality, all the big things that we have talked about into the Constitution of India, that constitutes constitutional morality. Like the directive principles, everything mentioned in the directive principles can be called as constitutional morality. If whether you are able to give some maternity relief or not, so that is constitutional morality. The rule of law, constitutional morality. Democracy, constitutional morality. Judicial independence, constitutional morality. Rule of law, constitutional morality. Like abolition of untouchability, constitutional morality. Everything that is there you can write as federalism, constitutional morality. All those things are constitutional morality. So you can write that. If you know the definition, if you know the doctrine of constitutional morality, you would have written the answers really well, right? So the next we shall see is how to answer this question, in which how to break this question. So first we need to see that we need to explain this statement, the statement that is given. Explain constitutional morality is the fulcrum which acts as an essential check upon the high functionaries and citizens alike. So whoever are there in the highest of the authority, be it the Prime Minister of the country, be it the President of the country, Vice President, or a common man. So all of them needs to follow this constitutional morality, and this acts as essential check upon the high functionaries and the citizens alike. So this we need to understand. The next thing that we need to do is we need to define a concept of constitutional morality. The second thing. Now, next thing is define judicial accountability and judicial independence and the significance of both of them. And then compare a bit between judicial independence and judicial accountability. And after that, how constitutional morality can be applied to ensure balance between judicial independence and judicial accountability. Judicial independence and judicial accountability. So this is how we have to maintain the flow of the answer. You see, none of the dimensions that has been talked about in the previous in this particular question have been left out, right? So these are all this was a 15 marker question, right? This is actually question number 11th. 1 to 5, I guess. 1 to 5, yes. 1 to 5 in 10 marker is polity, and then 11 to 14 in 20 marker, in 15 marker is actually polity. So 50 marks there, and here you have 60 marks. So it's total 110 marks from polity sections only, right? And after that, we can see the model answer. We have done the same thing. We have conceptualized the statement. Supreme Court has said this. It implies that all organs of state, including judiciary, must act within the boundary of constitutional principles, ensuring both accountability and independence. What is the concept? It was coined by Dr. B.R. Ambedkar Sahab. It refers to adherence to the core values of the Constitution, like rule of law, equality, liberty, accountability, respect for institutions, right? It ensures power is exercised not just legally, rather ethically as well. So this is mentioned over here. The next thing is judicial independence, right? And judicial accountability. Of course, judicial independence is ability of the judges to pronounce the judgment without any external interference or external influence, external pressure. And judicial accountability is like upholding transparency, integrity, and responsibility in their conduct and decisions, right? Significance: it prevents misuse of judicial powers and sustains public trust in judiciary, right? So that is very much important. Now, judicial accountability versus judicial independence, and that is mentioned over here. Like, what is the definition I have mentioned, and the constitutional basis. What is the constitutional basis for judicial independence and judicial accountability? Removal provisions, judicial conduct subject to parliamentary scrutiny. What are the significance, risk if absent, and the examples, right? So all of this I have mentioned over here. You can go through that, right? How constitutional morality ensures balance, code of conduct and ethical standards, judicial review, collegium system versus transparency, and all of this, like, right? And there was a landmark judgment of NJAC case 2015 that upheld judicial independence, right? And this NJAC case, NJAC thing was not absolutely wrong, but still it was struck down by the judiciary. So NJAC actually, National Judicial Appointments Commission Act, this act actually talked about appointment in the judiciary. And there was some involvement of executive into that, but that became the fourth judge's case, right? Fourth judge's case, because judiciary said that it is, since it was actually, involving executive in appointment of judiciary, it would have violated the independence of the judiciary, and therefore they struck it down. And this will lead to another question in this examination only, that is evolution of collegium system for appointment of the judges. So one thing, looking at the 2025 questions of GS2, we can say one thing for sure, that UPSC is not really very happy with the Supreme Court. So one question we just saw, this one, right? The constitutional morality one, they linked it with actually the judgment was for the executive and legislatures to follow, but the UPSC turned the table around and they asked the same question from UPSC. There is one more question on this. I'll go to that. Yes, this question only. Discuss the, this is question number 13 in this year's papers. Discuss the evolution of collegium system in India. Critically examine advantages and disadvantages of the system of appointment of judges of the Supreme Court of India and Supreme Court of the USA. Supreme Court of India and Supreme Court of the USA. So once again, they have integrated two topics. One is structure, organization and functioning of executive and the judiciary, one, and plus the next is comparison of constitutional scheme of India with that of the other constitutions of the world, right? So this is very important, that discuss the evolution of collegium system, how it evolved. There are 4 judges case, and through that it evolved, and then they are asking to write down the advantages and disadvantages of the system of appointment of the judges of Supreme Court of India, advantages and then disadvantages of the appointment system of the judges in the Supreme Court of India, then again advantages of the appointment system of the judges in the Supreme Court of the United States of America, and the next will be the disadvantages of the system of appointment of the judges of the Supreme Court of that of the United States of America. So those are the things we needed to write. The next we need to see is the questions that's asked in the previous question. Is there anything? So critically examine Supreme Court's judgment. Critically examine means you have to criticize. Whenever critically is there, if you are writing 10 point, once again 6:4 ratio. 6 in the criticism, 4 in the favor. Critically examine Supreme Court's judgment on National Judicial Appointments Commission Act 2014 with reference to appointment of judges of higher judiciary in India. With reference to appointment of judges in the higher judiciary in India, right? Discuss the next question. This was asked in 2017. Discuss the desirability of representation of women in higher judiciary to ensure diversity, equity, and inclusiveness. So this is also related to appointment of women in the higher judiciary. This is also being critical. 2021. This is also being critical of the judicial appointments thing or procedure. So currently what is the procedure that we are following in appointments in judiciary is that of collegium system. Like president has to consult for the CJI before appointing anyone as the judge, and the CJI in turn has to consult 4 senior most judges. So 4 senior most judges plus CJI becomes 5, and they need to send their recommendation back to the president. So that is very biased system. Also there is a debate that only few families have been represented into the judiciary, like D.Y. Chandrachud. His father was also the judge. Similarly, there are other Chief Justices of India or judges of the Supreme Court whose father was in the judiciary. So this system of appointment in the judiciary is very much criticized, and you can see the trends into the UPSC. Here as well, this appointment only question number, this is a woman, or here NJC, here collegium system, or the one question that we just saw, that also is related to that only. So this is very important. So we need to see how we are going to answer this question. So define the collegium system in India plus 99th Constitutional Amendment Act, you need to relate it with. And then evolution of collegium system, like 4 judges cases, first judges cases was there, second judges cases was there, third judges cases were there, and then the last 4th judges cases, which is the NJSC. Then you have to write advantages and disadvantages of system of appointment of judges, Supreme Court of India, and advantages and disadvantages of system of appointment of judges of Supreme Court of the USA, and steps taken to rectify the procedure and any recommendations if you have. Right? So collegium system in India, once again I have defined you can see the advantages and disadvantages have been there. It ensures judicial independence from executive interference, senior judges, collective wisdom, reduces arbitrariness, protects, and something like that is there. All those things. Here in the United States of America, Senate confirmation is required. Right? Presidential nomination and Senate confirmation is required. In India, those things we are oblivious of. But UPSC wanted us to know this thing, that how those systems run over there, right? So transparent process is there with open Senate hearings, accountability ensured by legislative oversight, ideological debates reflect democratic values, lifetime tenure secures independence once appointed, and wider public scrutiny enhances legitimacy. So when you'll watch these movies, this series, there is one series called, very popular one called House of Cards. So when you'll see that series, you'll realize what the points we are talking about. You don't have to watch it now, but if at all time permits, after mains, you have just been done with mains, and those who have written it, you can watch it. 6 season is there, and extremely interesting. When I was watching it, I used to get dreams of that President Underwood. He is a very, extraordinary character in that series. So you'll understand how he has played with these things, judicial appointments and all, right? And this is highly politicized, partisan process, ideological bias overshadows merit, lengthy confirmation battles, delays justice, judiciary perceived as politically aligned, public trust shaken during controversial appointments. You are getting my point? So all those things are there. What are the steps that has been taken and what are the recommendations that has been made? All those things are written over here. All of them will talk what? To maintain transparency. Like Law Commission 214th report said that need for broad-based judicial appointments commission with checks and balances. Second, ARC said transparency and accountability while retaining independence. NCRWC 2002 said independent National Judicial Commission with representation from judiciary, executive and legislature and civil society. Institutionalize the criteria, regular audits and public reporting on vacancies and appointments you need to make. You are getting my point? So this is the 13th question that we just answered. One question we had left here, and this is a very direct question. This is a very direct question, like amending power of the Constitution. So there is the first topic, Indian Constitution, historical underpinnings, evolution, features, amendments. So here they have asked a question form. This topic, all of us actually ignore, but this topic should not be ignored because this is important from prelims as well as from mains perspective. So you need to prepare this topic on amendment really well. So what is the question saying? Question saying is Indian Constitution has conferred amending power on the ordinary legislative institutions, true, with a few procedural hurdles. Few procedural hurdles are there. In view of this statement, examine the procedural and substantive limitations on amending power of the Parliament to change the Constitution. You are getting my point? So you read the question once again so that you can answer it as per the demand of the question. Having read the question, was there any question asked in the previous discussion? Yes. Parliament's power to amend the Constitution is limited power and it cannot be enlarged into absolute power. This is the Seedha judgment of the Minerva Mills, right? In light of this statement, explain whether Parliament under Article 368 of the Constitution can destroy basic structure of the Constitution by expanding its amending power. 2019, it has been asked, right? So now, how do we need to solve this question is, we need to see, define the amendment of the Constitution, okay, which article and what all is there. Define procedural limitations on the amending power. Define substantive limitations on the amending power. What are the steps that have been taken, relevant cases, and what are the recommendations? What are the procedural and what are the substantive limitations? Procedural limitations, we all know that it requires, there are two, actually the article is 368 to amend the Constitution. It is included in part 20 of the Constitution, and there are two types of amendment under Article 368. Total, there are three types in which the Constitution can be amended. One of them is simple majority, which do not come under Article 368 of the Constitution. Insofar as Article 368 is concerned, it only consists of two types in which the Constitution can be amended, right? So this is the thing, that the procedural delay, procedural limitations, that is under Article 368, you need to pass the bill through the special majority, that is 2/3 of the people present and voting plus 50% of the total strength, 50% of the total strength, right? So this is what is required, special majority. In the second type, this is special majority plus ratification by half of the states is also required. So we need to see all those things in this answer, right? So let us see the model answer? The model answer is like this. You need to define the amendment of the Constitution, and after that you need to talk about the articles in which it is mentioned and how many types are there. Total 3 types, but under 368 only these 2 are there. These 2 are there under 368. This is not considered under Article 368, right? Not considered under Article 368. What is the procedural limitations on the amending power of the Parliament? That is, initiation of amendment only by Parliament and not state legislature. This is also important. Certain amendment features, amendments like federal features require require ratification by at least half of the states. The President must give assent to the constitutional amendment bill, and no provision for referendum or citizen approval, or there is no provision for joint sitting or something like that. What is substantive limitations? Substantive limitations is like basic structure doctrine should not be violated. So those things are there. What is the steps taken? Those who have studied knows all the cases of basic structure doctrine. You need to write all those cases, and after that you need to write the recommendations, right? What are the guidelines they have talked about, NCRWC, then Law Commission reports, right? All those things we need to mention in this as well, right? So now moving to the last question in the polity section. Last question. Now next is examine the evolving pattern of center-state financial relations, right? Very specific evolving pattern of center-state financial relations in the context of planned development in India. In the context of planned development in India, how far have the recent reforms impacted the fiscal federalism in India? What are the, of course, we need to talk about the recent reforms and how far has it impacted the fiscal federalism. Now, is this question in isolation, has been asked in isolation? Actually, no. We need to see the previous questions to realize the same. What changes has the union government recently introduced in domain of center-state relations? Had you prepared it? The financial relation is sub-part of it, right? The next thing is suggest measures to be adopted to build the trust between the center and the states and for strengthening federalism. The trust between the center and the states and for strengthening federalism. The next question. How have the recommendations of 14th Finance Commission enabled states to improve their fiscal position? And one question was there on 13th Finance Commission as well. So these 2 questions, if you would have prepared, they would have helped you answer this question very clearly and very nicely, right? So all those things, having said that, you just see that what all we need to write in the answer. So you need to first of all define the center-state relations, and in this you need to define both administrative, all the 3, administrative, legislative and financial relations, and the relevant articles you can mention aram se. Then you have to write evolution in the pattern of center-state financial relations, right? Vis-a-vis planned development, with respect to planned development, right? And what are the recent reforms that was introduced to improve center-state financial relations, positive impact of those reforms, and here the negative, by mistake it's positive only, negative impact of recent reforms, because the question was asked, and what was the question? How far have the recent reforms impacted fiscal federalism? So when it comes to how far, we need to mention how far in both the things, positive as well as negative. It has improved to some extent, but so and so are the flaws that is still there. And then what is the recommendations that you suggest, right? So this is the questions. You see, rooted in Article 268 to 293, Finance Commission's planning mechanism. These relations have undergone significant evolution, right? All of this. Define center-state relations over here, and then evolution of center-state financial relations vis-a-vis planned development. When you'll see here, pre-planning era, till 1950, Finance Commission was the boss. Planning era, 1950 to 2014, Planning Commission played key role, right? And Modi ji, Prime Minister Modi was Chief Minister of Gujarat. So the issues that he might have faced as soon as he came in the government in 2014, the first thing he did in 2015 was planning commission was abolished. And when the planning commission was abolished, the finance commission regained the primacy, because the Niti Aayog is actually a think tank. They have got no role in allocation of funds, right? So these are the things. And then 14th Finance Commission said, raised the tax devolution to 42% directly from 32%. Right? And then 15th Finance Commission 2022 1 to 26 fixed at 41% post J&K reorganization with performance-based grants. What are the recent reforms to improve center-state relations? That is, goods and services tax, FRBM review committee 2017, and then we have seen Niti Aayog, Finance Commission, and debates on cess and surcharges and all. So all those things are what? The reforms, recent reforms only, right? You could answer all these things, and then you have to answer impact of recent reforms on fiscal federalism, right? So these are the reforms, and positive and negative impacts are mentioned side by side, right? And what is the recommendation? Finance Commission should have a broader role. GST needs to be reformed, as Prime Minister Modi has announced from the Red Fort, that there will be some reform by Diwali this year, and we can expect that same thing. They will reduce cess and surcharges, and moreover, all these points are there, right? Yeah. So these are the questions that had been asked in the in this year's question, right? And if you would have been serious, I always tell this to my student and to you as well, as I started in the beginning. First of all, you have to check the syllabus. Next, you have to see is the previous year's questions, PYQs, and you have to incorporate both the things in your notes, right? Once the notes are prepared, you know, when you write the themes on previous question, you incorporate one or two additional dimensions on that topic. On whatever topic the question has been asked, one or two additional dimension you prepare your notes on. Once the notes is prepared, you need to revise it every now and then. Revise it as many times as possible. Once the revision is going on, you need to practice. Write answers like anything. If at all you want to clear mains, you need to write answers. So these are actually 5-step formula I always give my student to clear this examination. Had you done this, had you incorporated this in your notes, of course you would have revised it, and based on that you would have written the answers as well, right? So next we'll move on to is the social justice section, as I have told you all in the beginning only. So let's move to the social justice section. So having seen the polity section, now let's start with the social justice section. Social justice. This is also very important. This time they have asked many questions from this. 2 in the 10 marker and 3 in the 15 marker. That makes it actually 15 3 45, and this 20 questions, 20 here. So 65 marks are there from the social justice section, right? 65 marks. So we need to prepare actually social justice really very religiously if you are preparing for UPSC mains examination. Now, let us see the question. The question says, women's social capital complements in advancing empowerment and gender equity. Empowerment and gender equity, it is talking about gender equity and empowerment. If woman has the social capital, women's social capital is like the connections that we have, the people and all we interact with. So that is what they are talking about. Women's social capital actually complements in advancing empowerment and gender equity. So now let us see if there is something in this regard in the previous year's question. So the previous year's question, when we go to see which steps are required for constitutionalization of a commission. Okay, constitutionalization of commission. Do you think imparting constitutionality to the National Commission for Women would ensure greater gender justice and empowerment in India? Give reasons. And this was asked in 2020 and the marks that it carried was 15 marks, like 250 words you had to write about it. So this, of course, you can say that this is not directly related to the question, but you need to understand the theme cannot always be the same, like welfare schemes for vulnerable sections of the population. That is actually the topic wherein it might fall, right? But you know, when it comes to UPSC, you need to, this is where your personal analysis matters. How you analyze the UPSC previous questions. It is a very subjective thing. If you give this to some other person, they may say that this is a new question asked by UPSC, but that is not the case, right? Why? Because if you will see the themes that has been followed by UPSC is women, and this I am talking in GS paper 2. In GS paper 1 there is a specific topic women related, right? So here you need to understand this theme. If you would have prepared on this theme, I think you would not have been let down by UPSC. So this is one question that is on the theme of women, right? That is one question on the theme of women. See how much importance UPSC gives to the women. Discuss the contribution of civil society groups for women's effective and meaningful participation and representation in state legislatures. Once again, their representation in a state legislature, and this was asked in 2023. So 2020 and this is 2023. So once again, their representation they are talking about in state legislature. Now let's move ahead. Discuss the desirability of greater representation to women in higher judiciary. This I had taken in the judiciary wala thing as well, but it fits in here as well. So you need to understand their representation in higher judiciary, their representation in state legislature, constitutionalization of National Commission for Women. Will it help women in any way, like in their gender justice, in gender empowerment or something like that, right? So, and the next, another question in this regard is, the reservation of seats for women in institutions of local self-government has had a limited impact on patriarchal character of Indian political process. So once again, reservation of seats in local self-government. So it is state legislature, it is local self-government, it is higher judiciary, right? All they are very much interested in knowing. Is National Commission for Women able to strategize and tackle the problems that women face at both public and private spheres? Give reasons. So once again, National Commission for Women, and are they able to strategize and tackle the problems that women face in both public and private spheres? So theme should not be the one. Theme should not be this welfare schemes for vulnerable sections of the society or something like that. It should be women. Theme can be children. Theme can be healthcare. Theme can be, the old age people. So all these are the themes that has been asked by UPSC, and that too very much frequently. So if you would have prepared the data on your topic on women, theme on women, I think you would have excelled really well in this paper. So now, what are the things that we can write in the paper? So once again, define social capital first of all, and what are women's social capital, or what can be women's social capital. And the next thing is how women's social capital complements in advancing empowerment, how women's social capital complements in advancing gender equity. These are the two things they have talked about. And also you can talk about is steps that has been taken to empower women and to have gender equity, and if there is any recommendations at all, if you have, right? So all those things you could write in this paper. So once again, in the model answer, I have done the same thing. I have incorporated definition of social capital, then definition of women's social capital, the networks and association of women through self-help groups, cooperatives, community organizations, and digital collectiveness. So these are the things that I think you should have mentioned in your paper, and acts as a support system enabling access to resources, opportunities, and voice in decision making. What can be the example? SHG movement under NRLM, women cooperatives in Kerala, for example, Kudumbashree. So these are the things that you could have mentioned in your answer. The next that you could have answered it, how women's social capital complements in advancing empowerment. So one is collective bargaining, you could have mentioned, builds confidence and leadership skills, strengthens access to government schemes, markets, and training, and all those things they could have you could have mentioned in this paper. So this would have been the most easiest answer you could write, right? And the next question is on civil society organization. And the topic is this. From this topic this year, 2 questions have been asked. One here and another question also you will find. Right? So this is another is a 15 marker question. Civil society organizations are often perceived as being anti-state actors rather than non-state actors. Now this again, this is the trend that is being changed by UPSC in some way or the other. How is that they want you to answer that they are actually not acting as non-state actors. What are the state actors? The state actors are the ones who are acting on behalf of state, and the non-state actors are like the ones who do not constitute in the definition of state. So they are outside the state, and in that definition only everything comes, like civil society organizations and all, NGOs, charities, and associations, everything, right? So what this wants us to see is that civil society organizations are actually acting more as anti-state actors than state actors. So this, if you could define, and there are this thing also, data also, there was data that almost 2% of the GDP we are losing because of the protests and everything that is going on in the country, and those protests and agitations are led by some organizations, some civil society organizations or the other. So now let us see whether this has got any correction in the previous questions. So one is public charitable trusts have the potential to make India's development more inclusive as they relate to certain vital public issues. Right? So okay, fine, not very direct, but yeah, from that topic only, from this role of NGOs, SHGs and others. Discuss the contribution of civil society groups for women's effective and meaningful participation in representation of state legislatures. So once again, civil society groups. Can civil society and non-government organization present an alternative model of public service delivery to benefit the common citizen? Discuss the challenges of this alternative model. So these are the questions that had been asked in the previous questions, not very directly, but yes, the previous year's question could have told you about the significance of this topic, right? So now we have to answer accordingly. So what we could answer in this question is, like, we could have given the intro part. In intro part we could have written if there is anything in news, and we could have defined CSO, civil society organizations. Now, why civil society organizations are perceived as being anti-state actors? You answer this. And then why civil society organizations are not perceived as being non-state actors? So what are the things that they are doing because of which they are not being perceived as a non-state actors, and then steps taken and followed by the recommendations in this regard. So when you'll see the answer, there is like FCRA rules have always been in news since this government has taken over. So Ministry of Home Affairs recently tightened FCRA rules, barring foreign funded NGOs from publishing news content, raising debates on civil space. Over 160 CSOs such as PUCL appealed for dialogue on Bastar amid security operations. Now, Bastar is a Naxal affected area. If the police is, or the administration is trying to eliminate Naxalism, now the civil society organizations come into play, and they are like, no, you should not do this, you should not do that, and all sort of things. So because of that, the government is like prohibiting them from doing any such things which could, hamper the operations that is ongoing in that area. The government is committed to, eliminate Naxalism by March 2026. So let us see how does it go. So this is what CSOs, civil society organizations, have also been active in climate resilient WASH interventions, demonstrating inclusivity and adaptive service delivery. Now define CSOs. So CSOs definition will be very easy. You can define it aram se. Now, why CSOs are perceived as anti-state actors? So why it can be? Because they are critical of the government. They are critical of the government policy, seen as obstructionist. Foreign funding raises suspicion of external influence, and dissent often projected in media as confrontation with the state. So all those things we could write in our answers, and there are other things as well you could have incorporated, right? Like issue based. For example, Naxalism, you could have written environment, you could have written, the farmer laws that was there. So in that also, CA protest, there was people civil society organizations involved. So all those things you could have mentioned, issue based as well, right? So all those things could be written very nicely. Now, why CSOs are not just the non-state actors? So we could have written all these points which I have mentioned. Steps taken, like NGO Darpan portal by Niti Aayog for transparency. FCRA amendments have been happening. PILs and judicial recognition of NGOs' role in advancing social justice, and partnership with CSOs in disaster management, education, and health campaigns. There are civil society organizations which are working really, really well. But there are some organizations because of which this trust deficit is there between the government and the policy makers, right? So these are the things you could have written in this answer. Now the next question is question number 15 in today's in this year's paper, which happened yesterday. So it is like role of NGOs, SHGs and various groups. The syllabus remains the same. Question is, what are the environmental pressure groups? Discuss their role in raising awareness, influencing policies, and advocating environmental protection in India. So first of all, they have asked pressure groups. That's true. But in the pressure groups also they have asked one question, that is environmental pressure groups. Environmental pressure groups, right? And now let us see if there is any previous question in this regard or not. So pressure groups play a vital role in influencing public policy making in India, right? And explain how the business associations contribute to the public policies. So pressure groups, what is their role in influencing public policy making? How do pressure groups influence Indian political process? Now another question. And do you agree with this view that informal pressure groups have emerged as powerful than formal pressure groups in recent years? Right? And the next question is, examine critically the recent changes in the rules governing foreign funding of NGOs under FCRA and 1976. This was asked in 2015. How can the role of NGOs be strengthened in India for development works relating to protection of environment? Now, this is a direct question. Environment, protection of environment, and here environmental pressure groups. Discuss throwing light on major constraints. 2015 only. This must be 12.5 marks question, 200 words. At that point of time, it was different marking schemes in 2015, 13, 14, 16, right? Pressure group politics is sometimes seen as the informal face of politics. As an informal face of politics. With regards to above, assess the structure and functioning of pressure groups in India. Very important. All these previous questions tells you the importance of this topic and also gives you these many themes to prepare from. So had you gone through the previous questions, you would have definitely prepared environmental pressure groups, because in 2015 they have asked this question directly, right? So you need to prepare the previous questions time and again. I just want to show you one thing only, that if you will prepare the syllabus, if you prepare the previous question, UPSC mains is not difficult cake to have, right? It's a very easy cake. All right. So now we need to see what we could have written in the answer that define environmental pressure groups. That's true. Then role of environmental pressure groups in raising awareness, in influencing policies, and in advocating environmental protection in India, and recommendations for the environmental pressure groups, if any. So now you need to define environmental. I have defined it over here. And then what it does in raising awareness, what it does in what role does it play in influencing policies, and what role it plays in environmental protection, and then recommendation for environmental pressure groups. Right, so all of these things have been mentioned over here. You can refer to the answer, right? The next is, I think this is the second last question in social justice section. Total 5 questions have been asked this year, and the second last question is inequality in ownership pattern of resources. Inequality in ownership pattern of resources is one of the major causes of poverty. Discuss in this context, in the context of paradox of poverty. Paradox of poverty is like what is paradox of poverty is, even when the development is happening, actually the poverty is not being alleviated, or it is not being eliminated. So one side development is happening, people are becoming rich, but the poor are remaining poor only. So that thing we need to incorporate in our answers. This is what is all about, this paradox of poverty. So in this context, you have to write answer on inequality or in the ownership pattern of resources. Like what are the resources that is being owned by the different individuals. So that ownership pattern of resources is actually one of the major causes of poverty. So now let us see if there is any question in the previous years on this basis. Can the vicious cycle of gender inequality, poverty, and malnutrition be broken through microfinancing of women SHGs. Microfinancing of women SHGs, right? So how this inequality, poverty and malnutrition can be taken care of, right? This was in 2021. Poverty and malnutrition create a vicious cycle, adversely affecting human capital formation. What steps can be taken to break the cycle? So this is the second question, that poverty and malnutrition create a vicious cycle. That is true. That creates a very significant vicious cycle. The next question in this regard is, the incidence and intensity of poverty are more important in determining poverty based on income alone. Our incidence and intensity of poverty, that is very much important factor in determining poverty based on income alone. In this context, analyze the latest multidimensional poverty index report 2020. Next question, microfinance as an anti-poverty vaccine. Very important. Microfinancing as an anti-poverty vaccine is aimed at asset creation and income security of rural poor, right, in India. Evaluate the role of SHGs in achieving the twin objectives along with empowering women and rural India. So that is another question related to, once again, these questions are integrated, has integrated two topics actually, SHGs and, poverty and something like that. There is growing divergence in the relationship between poverty and hunger in India. The shrinking of social expenditure by the government is forcing the poor to spend more on non-food essential items, squeezing their food budget. Food budget is being squeezed. Once again, hunger and poverty are the biggest challenges for good governance in India still today, right? Till today. Evaluate how far successive governments have progressed in dealing with this humongous problem. Suggest improvement. Once again, poverty alleviation programs in India remain more showpieces until and unless they are backed by political will. Discuss with reference to the performance of major poverty alleviation programs. This was in 2017. Now the next question is, though there have been several different estimates of poverty in India, all indicate reduction in poverty levels over time. Do you agree? Critically examine with reference to urban and rural poverty indicators. Once again, the SBLP SHG bank linkage program, which is India's own innovation, has proved to be one of the most effective poverty alleviation and women empowerment programs. Elucidate. So all of these topics incorporate what? Incorporates poverty only, right? Incorporates poverty only, and it has integrated two topics and asked a question. So now let us see, inequality in the ownership pattern of resources is one of the major causes of poverty. Discuss in the context of the paradox of poverty. This is a 15-marker question, and what we could have written in the answer is, we could have first of all defined the paradox of poverty and then would have given some data related to poverty, right? Paradox of poverty and data related to poverty. The next thing is how inequality in the ownership pattern of resources is one of the major causes of poverty vis-a-vis paradox of poverty in relation to paradox of poverty, and then enumerate other causes of poverty, steps taken to eliminate or reduce inequality in the ownership pattern of resources, and recommendations in this regard. So accordingly, I have incorporated these things in my model answer, and that is, here you can see that we have defined poverty. Poverty in India remains persistent challenge despite decades of planning and rapid economic development. Paradox of poverty: coexistence of widespread poverty amidst abundance of resources and wealth. So these are the things that we needed to mention in this answer, and data I have mentioned over here: multidimensional poverty index, Oxfam, NFHS, all these data have been mentioned over here. You could refer to those data. Now, how inequality in ownership pattern, this one, the heading that we talked about, we have tried to answer this question. Land ownership concentrated in few hands, unequal access to credit, irrigation, technology and markets, corporate dominance in natural resources, mining, forests, etc. Wealth accumulation by elites results in exclusion, and others. Other causes of poverty is here, and what are the steps that has been taken, right? So this all has been mentioned over here. You could refer to these things, right? Now the last question in social justice section, total 9 question was there in polity, and 5 question was there in social justice. 4 question is there in IR, like always, and 2 questions are there in the governance sector and governance section, and that is also like always. So the last question in this social justice section is National Commission for Protection of Children, right? NCPCR has to address challenges faced by children in the digital era. Very important. Those who are preparing for UPSC very seriously, this digital era and its impact on vulnerable section becomes really important, right? Like in GS paper 1, there is impact of globalization on vulnerable section. So it was asked about old age people. The next time it had asked about the women, and here in this paper it has asked about the impact on children or challenges faced by children in the digital era. And NCPCR has to address this challenge, examine the existing policies and suggest measures to the commission can initiate to tackle the issue. Now, where when the theme is children, we need to understand this as well. The question is that Right to Free and Compulsory Education Act 2019 remains inadequate in promoting incentive-based system for children's education without generating awareness about importance. Children, examine the main provisions of National Child Policy and throw light on the status of its implementation. This was asked in 2016. So, and NCBC, the question had already been asked, and NCW, the question had already been asked. NCBC is National Commission on Backward Classes, and NCW is National Commission for Women. On these two, the question have already been asked. The next was National Commission for Protection of Child Rights, right? So we have seen the question. Now, how could we address the question? And to address the question, you need to address the demand of the question. The demand is the challenges faced by children in digital era. Any relevant data or news? There are plenty of data with in this regard available on the internet and in the current affairs as well. What steps NCPCR has taken so far? What are the existing policies, acts and schemes in this regard? What is the positive impact of these policies? What are the steps taken by other institutions and recommendations to the Commission to tackle the issue, right? Recommendations to the commissions to tackle the issues, and all those things we need to take care of. So these are the things we needed to answer in this particular question. So accordingly, I have created this model answer, wherein you will find all the data with regard to UNICEF, India, over 24% of children 5 to 11 years and 56% adolescents are internet users. This is data from IAMAI. And what have been recent concerns? Rise in online child sexual abuse material, gaming addiction and exposure to violent and explicit content. So these things are actually bothering the policy makers, because you see the data, you see 56% of the adolescents between 12 to 17 years and 24% of the children. I don't think this data is correct, because if we consider the infants, their mothers nowadays, in order to feed the children, they have to show the content on internet. So they also become internet user only. The children of 1 year, 2 year, they know how to scroll the videos, the reels. So mothers usually, because they are very busy, they are keeping very busy, because of which they are handing over the mobile phone or iPad or tab based on the resources that is available with them. They provide it to them. And also there is this television channel, and on the television, YouTube they are putting on, and after that they are giving the remote to the children. And there, if we include them, I think the data will be too much. Almost all the children are doing that, right? Without that, they are not only doing anything. And because of this, that isolation also has increased in the society. Earlier, the children used to go to play in the park. Now it's a luxury. Now parents are actually dying, or feeling wishing to take their child to park, but they are not able to. So these are the data that is available for the children. Now, what are the challenges faced in the digital era? Digital bullying, online sexual exploitation, the gaming and social media, privacy violations, unequal digital access, and everything. Right? What are the steps taken by the NCPCR? That is, they have issued guidelines to edtech companies. They have given guidelines to edtech companies to protect child's data and mental health, launched inquiries, developed awareness campaigns, recommended stricter implementations of IT rules 2021, and all these things. What are the existing policy? IT Act, POXO Act, Juvenile Justice Act, National Education Policy, and Digital India Program, and PM E-Vidya for inclusive e-learning, right? Existing policies and acts. What is the positive impact? What are the steps taken by other institutions, and what are the recommendations, right? So these are the things that has been given into this, that could be written into this answer, right? So once again, I'll after this section as well, I'll tell you the same thing, so that you keep it in your mind forever. So you need to watch what? First, the syllabus, followed by PYQs, previous questions. You need to incorporate these two things into your notes, and once the notes is ready, what becomes easy is the revision. And once the revision you are revising, you need to practice, and in practice you shall do what? You shall write the answers. And for answers, I'll recommend you all to, before attempting the mock tests, you write the answers of the previous questions. That will benefit you a lot. So that will be all in this social justice section. Now let us move to the governance section. In the governance section, there is only this thing, two questions that has been asked this year. So let us move to the governance section. So in governance section, when you'll see the question, the first question, that is the 7th question in the examination. E-governance projects have a built-in bias towards technology and back-end integration rather than user-centric designs. Right? So this you need to, I think, understand first, that e-governance projects, they are saying that it is actually, it has built-in bias towards technology and backend integration. It is not focused on user-centric designs. So this we need to examine, that whether it is true or it is false, right? So before we proceed further, there is a direct syllabus given in this regard. E-governance applications, applications of e-governance, you can break it like that, models of e-governance, successes of e-governance, limitations of e-governance, and potentials of e-governance. All those are mentioned in the syllabus. Now let us move to the previous question. E-governance is not just about routine application of digital technology in service delivery. It is much about multifarious interactions for ensuring transparency and accountability. In this context, evaluate the role of interactive service model of e-governance. So one of the model of e-governance is interactive service model. Next is e-governance as a critical tool of governance has ushered in effectiveness, transparency, and accountability in governments. What inadequacies hamper enhancement of these features? The next is emergence of fourth IR, that is digital revolution, has initiated e-governance as an integral part of the government, and discuss. E-governance is not only about utilization of power of new technology, but also is about importance of the use value of information. Explain. So these are the things, questions that has been asked in the previous question. Had you prepared this part of the syllabus and these themes asked in the previous questions, I think this question would have been easier for you. So now what we would have written in the model answer is that if there is anything in news, define e-governance, and how e-governance projects have built-in bias towards technology and backend integration, how e-governance projects have built-in bias against user-centric design, steps taken to resolve it, and recommendations if any. So we need to define e-governance here, and also we need to see whether there is anything in news. So yes, there is something in news. Niti Aayog reports, CAG performance audits, and Parliamentary Standing Committee reviews of schemes like CoWIN, Bharat-Ret, Aadhaar-based DBT have highlighted challenges of accessibility, inclusivity, and experience. So bias, how is it biased? That we need to see. So focus on digitization of records, large databases, biometric authentication, and interdepartmental integration. Biased against user-centric, interfaces complex, mostly English, excludes rural and elderly or illiterate users. So it is in English that interaction is not able to happen. Rural-urban digital divide is there, and CoWIN portal initially inaccessible to citizens without smartphones. So those who doesn't own a smartphone will be a loser in this digital era. So that is the problem that we are facing as of now, and this needs to be corrected. So that is the first question in the governance, that is with regard to e-governance. Now the second question in this regard is, in contemporary development models, decision making, problem solving responsibilities, source of information, and execution. What it is saying is, in contemporary development models, decision making and problem solving responsibilities are not located close to the source of information and execution, defeating the objectives of development. So this question, when you see, there are four factors that is related to, that is involved in the development process. One is development decision making. Second is problem solving responsibilities. Third is source of information, and fourth is execution. All of them are apart from each other and far away from each other, because of which the objective of development is being defeated. So that we need to see in this regard. Is there any question in this regard? So the topic is government policies and interventions for development in various sectors and issues arising out of their design and implementation. This is about their design and implementation, right? So this we needed to answer. In the previous question, when you'll go, public charitable trusts have the potential to make India's development more inclusive as they relate to certain vital public issues? Do you, the next question, once again, this is related to development only. Do you agree with the view that increasing dependence on donor agencies for development reduces the importance of community participation in the development process? Here also, development models, here development process, here development to be made more inclusive. Crucial aspect of development process has been the inadequate attention paid to the human resource development in India. Suggest measures that can address inadequacy, right? 2023 and this question 2022, this question 2024. In the context of neoliberal paradigm of development planning, multi-level planning is expected to make operations cost-effective and remove many implementation blockages. Discuss. This is a 2019 question, right? So all these questions, when you'll see, you'll find it interesting that a development and development process and development models are very much important topic, or you can say the love interest of UPSC. So you could expect questions from here. If you would have prepared all these themes, you would have been able to answer this question really well. So once again, define the development models and a role of decision making, problem solving responsibility, source of information and execution in development, reasons why they are apart, and how this can be incorporated, or how this problem could be solved, steps taken and recommendations in this regard, right? So this will be this looks like an abstract question, but you can say that this is very much an integral part of the syllabus. And also the previous year, looking at the previous questions, I believe this question was could be expected in this examination. So this is all about the social justice section of this paper. The next is international relations. The next is international relations, and in the international relations, when we'll go to see, there are 4 questions, 2 in the 10 marker and 2 in the 15 marker, right? So when you'll see those questions, you'll realize once again in that also there is no surprises whatsoever. So you need to, you can expect the same thing. The question is, India-Africa Digital Partnership is achieving mutual respect, co-development and long-term institutional partnership. Elaborate. So the theme over here is Indo-Africa, bilateral. Right? Bilateral agreements involving India or affecting India's interests. Regional agreement or involving India or affecting India's interests. Global groupings and agreements involving India or affecting India's interests. So this is bilateral. Indo-Africa Digital Partnership. Something of that sort we are having. Is achieving mutual respect, co-development and long-term institutional partnerships, and we need to elaborate. The question asked in the previous question is, if the last few decades were of Asia's growth story, the next few are expected to be of Africa's. In the light of this statement, examine India's influence in Africa in recent years. 2021. Increasing interest of India in Africa has its pros and cons. Critically examine. 2015. So if you could have learnt a bit from previous question, I think you would have been able to answer this question really well. And how we could answer, or how we would have proceeded for this answer is that first of all, Indo-Africa was very much in news because of the recent tour or trip by Prime Minister Narendra Modi. And what is the India-African Digital Partnership? How Indo-Africa Digital Partnership is achieving mutual respect, co-development and long-term institutional partnership, steps taken to strengthen Indo-Africa relations and recommendations to strengthen Indo-Africa relations. So these are the pointers. If you would have answered in the examination, I think you'll fetch more marks, right? So these are the things. Indo-Africa ties are a cornerstone of South-South cooperation rooted in shared colonial experiences, democratic values and developmental aspirations. Recently in news due to African Union's admission into G20 during New Delhi summit in 2023, India-Africa Defence Ministers conclave and India's push for exporting the digital public infrastructure such as UPI and Aadhaar stack models. So what is India-Africa Digital Partnership? We could see here how this partnership is achieving mutual respect, co-development and institutional partnership. What are the examples? What are the steps taken by India and Africa in this regard? And what are the recommendations in this regard? So these are the things that you could have mentioned in the examination and you would have fetched more marks. This is just for the reference. I have collected these points. I have made very clear in the very beginning that you should not expect any model answer in this session. Right? The only thing I wanted to highlight is the significance of the previous questions, right? So that is very much important for me. Now, for this question, I did not find anything similar to this, but of course, when you will see the questions, when you will focus, when you will go to GS paper 1, you will find some question on globalization or post-Cold War era. So those are the things you could relate with in this question. So only if there was some direct question or directly related to the question in the previous question, I have taken it over here. So 2 questions I have not brought any previous questions for. Rest of the questions we have PYQs. With the waning of globalization, post-Cold War world is becoming a site of sovereign nationalism. Of course, it's becoming a site of sovereign nationalism. All the, across the globe. Now the globalization is really waning, and it's waning very fast. And looking at the Trump era, it's more visible and conspicuous in its presence, right? By its presence. So we can understand that globalization is waning, and the post-Cold War era has become a place for sovereign nationalism. Like everyone is looking at their own interest, their own national interest, and that is what we are referring here as sovereign nationalism. So in the intro section, you could have written globalization and post-Cold War cold era. You could have related it, some relation in this. You could have mentioned then instances of waning globalization, how post-Cold War world is becoming a site of sovereign nationalism. You could have mentioned North America, South America. In North America, United States of America is trying to build a wall between Mexico and the United States of America. They are like tariff wars. There is, visa issues and everything. All sort of things is going on in South America, Brazil, and all other countries. They are trying to save themselves. In Europe, we saw Brexit and all happening. In China, India is having Atmanirbhar Bharat, vocal for local. China has their own thing, right? So all these things are going on. Africa, same. Australia also same. And what are the steps taken in this regard, and what is the recommendations that we can make? So next comes is the model answer. So what I have already told you what we could have written over here in this model answer, in our answer, and accordingly I have taken the things over here as an just for the reference purposes. Right, so moving on to the next question, and this question you will be surprised to find the same into the previous question, exact question, right? Like the other questions that I showed. Energy security constitutes the dominant kingpin of India's foreign policy and is linked with India's overarching influence in Middle Eastern countries, right? In Middle Eastern countries. Leave it there only. Come to here. The question of India's energy security. constitutes, right, most important part of India's economic progress. Analyze India's energy policy cooperation with West Asian countries. Middle Eastern countries, West Asian countries, same thing. Just the terminologies change. I was listening to the other day one very prominent lady, I do not remember her name, but she was, I guess, from West Asia, I'll say. Because she got hurt. She was not okay with this Middle Eastern terminology that was used for her. And her argument was that this Middle Eastern is a colonial phase. I was not convinced. Then I heard her. So her argument was Middle East to what? Middle East to what? And that was very important for all of us to understand. It was actually India and China is called as Far East. Far East to what? So London is taken as a reference. UK, Britain is taken as a reference. And in reference to Britain, actually, of which we were the colony, or you can take it as Europe, right? So in reference to Europe, these West Asian countries are actually the Middle Eastern countries that comes into that Middle East area. And the India and China comes in the Far East region. So she was like, better use West Asia or use North Africa for that matter, right? But do not use the term Middle East. But the UPSC this year has used this Middle Eastern term. In the previous question 2017, they had used West Asian only. So same question, almost same question they have brought in. If you would have prepared the pre-IQ, you would have written the answer like flawlessly. How would you integrate energy security with India's foreign policy trajectories in the coming years? The next part of the question I just studied. The next question, discuss the geopolitical and geostrategic importance of Maldives for India with a focus on global trade and energy flows. Further, also discuss how the relationship affects India's maritime security and regional stability amidst international competition. Then again, clean energy. This year, energy security question was expected, and we know the reason, right? All that Russia and tariff war is going on. Russia-Ukraine war is going on. The US is imposing tariff on us, and any serious aspirant would be aware about the issue. So this question was again expected on the expected lines. And nothing much to discuss in this. We can discuss this. What could be the flow of the answer? So controversy around energy security. How energy security constitutes dominant kingpin of India's foreign policy. How energy security is linked with India's overarching influence in the Middle Eastern countries. Measures taken to integrate energy security with India's foreign policy, and measures to be taken to integrate the energy security with India's foreign policy technologies in trajectories in coming years. And this could be the answer, right? Here I have taken certain things for reference purposes. And the last question of IR as well as last question of today's session that we are having is the United Nations, right? So reform process in the United Nations remain unresolved because of the delicate imbalance of East and West, okay, and entanglement of China, USA and Russia-Chinese alliance. Examine and critically evaluate the East-West policy confrontations in this regard. Now, the previous questions, if there is any, discuss the impediments India is facing in its pursuit of a permanent seat in UNSC 2015. 2024, terrorism has become significant threat to global peace and security. Evaluate the effectiveness of UNSC's counter-terrorism committees. This is 2024, and the topic is important international institutions, agencies, forums, their structure and mandate. So this is the question that is asked, and this you can like if you're not aware about the issue, then you could face some challenge. But if you could have seen the previous question, prepared this UNSC reforms and the reform that the third world countries, or say the India, Brazil, BRICS nation and all are asking for the reform, I think you could have answered this question really well. And the question, how we could have proceeded in this answer is introduction, that is debate around reforms in UN, reasons for the demand of reforms, how delicate imbalance of East and West and entanglement of US and versus Russo-Chinese alliance impacting reform process, what are the East-West policy confrontations in this regard, and what are the steps taken to reform the UN, and what are the recommendations. So this is what we could have mentioned in our answer, and accordingly I have mentioned over here the answer, model answer as well. So you could refer to these questions and these model answers. You can take the screenshot of the model answer, incorporate in your copies, or you can brainstorm over this. So as I had mentioned earlier, that the object of this, as I had mentioned earlier before we started, that the object of this session was not to, have not to expect anything, not to expect model answer, right? But what I had seen is that I'll show the significance of PYQs, also the static and importance of static plus dynamic portion of the syllabus. The current affairs to be incorporated. So we saw all these things in our session. So that will be all for today's session. I'll urge you all once again, I'll repeat my point, to please refer to the syllabus first. After seeing the syllabus, please refer to the PYQs. Try to find some theme in that and incorporate it into your notes, and based on that notes revise that notes as many times possible, and then practice answers. Before writing answers or in the mock tests, I'll ask you all or request you all to first write answer of previous questions and then go for mock questions, right? Then go for mock questions. So that will be all from my end in GS paper 2. I hope you have got the points that I wanted to make, and I hope you will prepare on the lines I have just mentioned by showing you multiple proof, right? So I wish you all the very best. Thank you so very much everyone for attending the session. That will be all. Thank you.